City of Stevens Point Finance Committee meeting, recorded March 10, 2025.
Okay, we'll call the meeting of the Finance Committee to order at 6:07 p.m. Could you take the roll, please?
Christensen.
Here.
Morrow.
I was deep in thought, people. Deep in thought.
Shuda.
Here.
Emer. Here. Broderick. Here.
Okay, so we have everyone present. Our first item our second item after the roll will be discussion of possible action on the consideration of claim from Intellirent, a flooding incident related to construction activities.
Yes. So this was related to the construction on Maria Drive. Basically, it's an apartment building that flooded during construction on Maria Drive. So the recommendation from the insurance company is that this would be the responsibility of the contractor that did the work. So therefore, the recommendation for the city is to deny this claim.
Okay. Is there anyone from the public that would like to speak to this item? Come forward, please. Identify yourself.
Jason Glashinsky, Town of Linwood resident, 2985 Maple Ridge Road, and one of the member owners of Intellirent LLC that owns the property at 925 Maria in Stevens Point. So first and foremost, excuse me, dropping everything here. First and foremost, I appreciate the opportunity to discuss this matter with you. Now, I did provide materials that were submitted within your packet. Has everybody had an opportunity to review those materials, and am I free to openly speak to those materials? Okay.
Yes.
Very good. All right, so let me begin by stating very clearly and under the advice of legal counsel that our goal is to reach an amicable solution with the city and the contractor regarding this matter with as little damage as possible moving forward. Thus far, the contractor has actually lied to their insurance company, which we have documentation to same, and they denied our insurance claim at this point. Contractor stated that they were never on site pumping water. However, there's members of the community that are here that can attest to that fact. Plus, we also have photographic evidence to that fact. So I do know, in fact, that they were mitigating water out of the storm sewer, which was failing to properly mitigate the water through the regular storm sewer system. I do also want to turn your attention to the letter that was sent to us, and I believe to the members of this committee, from the treasurer, Mr. Corey Laddick. He makes a statement in his letter that the area was under construction, and therefore any liability would be the responsibility of the contractor, not the city. And with all due respect, while the city is afforded certain protections from liabilities when it comes to contractor work, but the city is by no means free of liability, and I'm going to cover that in just a moment. Additionally, the city is self-insured for these types of incidents, as outlined in the letter that was provided by the insurance company. So this is not an insurance matter. This would be a matter of whether or not the city chooses to use their funds as they're self-insured for these liabilities. Under Wisconsin State Statute 779.14, municipalities are required to ensure that payments of performance bonds with contractors for whom they perform work are adequately monitored by the city. And in this case, we do believe that there's a possibility that the contractor could be deemed an agent of the city, and therefore the city does have liability for their agent's actions. Additionally, under negligent hiring, section, bear with me for just a second. Under Wisconsin Civil Jury Instructions 1383, the city is liable for performing due diligence performing due diligence on contractors prior to engaging in a contract with for them to perform work. I did some just very cursory searching, and if you look on CCAP, this contractor has over 22 entries in the CCAP system. Other contractors who are capable of doing this work have 3 or 4, yet this contractor has over 20. And so I think I would be remiss if I didn't bring up that if we were all given the choice to hire a contractor and one of them has 3 or 4 entries on CCAP and the other one has 23 or 24 entries, we'd probably give pause before hiring that contractor to do any personal work on our personal residences, and should do the same for the city. I was not present when the contractor was awarded this job. But the process of due diligence under negligent hiring is going to end up coming to light if we can't find some type of reasonable agreement. There's also the public duty doctrine, which says that the city is required to perform certain duties, such as mitigation of rainwater. That is a city responsibility. Relevant case law applies in multiple instances. Bosco LLC versus Milwaukee Metropolitan Sewer District, and there's also reference to this in Wisconsin State Statute 893.80. So in conclusion, what we're hoping here So we are seeking the city's support in resolving this matter by covering some or all of our damages and assisting in holding the contractor accountable, whether by pursuing them directly or helping to facilitate a fair settlement. Unfortunately, the contractor has already denied our claim, which appears to be common practice based on the CCAP records and the previous incidents that was reported not down the road, not just a handful of houses down the road from our building earlier this year, where the residents were forced to sign a non-disclosure agreement in order to find an amicable solution from the contractor, which Attorney Beveridge even mentioned in this open forum that was a very odd practice. If we're unable to reach a solution with the city, our next step will be to formally pursue legal avenues to determine responsibility for the damages to our property. This process would include naming all relevant parties, including the contractor, their insurance and bond provider, the city of Stevens Point, its insurer, any city employees or representatives involved in the decision to hire that contractor, including but not limited to all committee members who were involved in the approval of that contractor in the due diligence process. However, our preference is to resolve this matter amicably and efficiently without the need for further legal action. We appreciate the opportunity to discuss a solution with all of you. Myself and my business partner are here to answer any questions that you may have. Thank you.
Thank you. Does any of the other city staff have any information that they feel would be helpful for the committee? Okay. Any questions, comments from the committee?
I have a question. I would like to know if the plaintiff is still pursuing anything with the contractor the city hired. Is there still any civil litigation going on? Or are you still trying to get something through him? I know they're trying to stall from what you were saying, but is there anything on? Have you filed anything to try to follow up with that?
Yes, please.
So we did pursue, first going to their insurance company first. The contractor denies that they were on site pumping water, which again, as I mentioned, we have evidence to the contrary. So at this time, the insurance company has said that they're going to deny the claim. So at that point, we sought legal counsel, and under the advice of legal counsel, we were advised that we should come here first, talk with the city first, and then if that doesn't get us anywhere, then our next step would be to pursue a civil claim with the contractor. So we have not done that as of yet. Okay. We would like to avoid doing that because we all know what happens when you start getting more lawyers involved and then having to go to court, and it just costs everybody more time and money and anguish and all that other stuff. So we're hopeful that we can find some type of amicable solution or workable solution with the city and with the contractor, all of us working together. But that's where it stands at this time.
Okay.
Any other questions from the committee? I noticed our city attorney entered the room. Logan, do you have anything you'd like to add to the conversation?
Mostly just here in case you had any specific questions, but one thing I do want to mention, your legal research would not have turned up the source of the city's protection against liability because it's actually contained within our contract with the contractor, which obviously you're not going to turn that up online very easily. But I can just say, if we were to hire contractors for this type of work with the understanding that we would take on liability for these types of things, boy howdy do I would hope we could pay them quite a bit less than we currently do. These types of things are unfortunate, but obviously this is very, very similar to the claims that you've addressed previously, a little bit further to the east on this same project.
So for further clarification, so there are specific clauses within the contract with the contractor that would.
Yeah, there are
Speak to the liability?
risk allocation, limitations of liability, indemnification clauses in every single contract that we sign for construction work.
Okay, thank you. Any other questions, comments from the committee?
I guess I just have a broader question. This is the third, and I believe the next agenda item is the fourth, related to this same construction project. Are there any additional incidents that we haven't heard of, or is 4 the number we're aware of at this time?
4 is the number that I'm aware of, unless, and I see Joel is nodding his head that
The 4,
that's,
okay.
these are the 4 that we're aware of.
Thank you.
Okay, any other comments or questions, otherwise, or a motion?
I would say because of the contract that we have, I mean, I would suggest that the plaintiff go through their legal representation in regard to the contractor for this, because that's the reason why we don't have our own, because if we did, we wouldn't have to end up hiring it out.
Right.
That's a motion.
That's a motion? Okay. So
The motion to deny the claim.
we have a motion to deny the claim from Alder Morrow. Is there a second?
I'll second.
Second by Alder Broderick. Any other comments?
Just a quick comment that I certainly empathize with the situation here, especially since we've seen a few with this contractor. And I think in this case, there is some compelling evidence. I certainly wish you the best of luck in pursuing this with the contractor. Fortunately, from the city perspective, it is kind of the same situation that we often see, where if we start to take on this sort of liability, it is not legally recommended for a number of reasons, which I do still feel apply in this case. So again, full empathy, best wishes for pursuing this further. Unfortunately, we, I think, have a clear route here from the city perspective.
Any other comments? Otherwise, all in favor of denying that claim would signify by saying aye.
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 And opposed would be no. So the claim is denied. That takes us to the next item on our agenda. Item number 3, consideration of claim, JADA LLC, sewer backup and flooding due to construction activities. Comptroller?
Yes, so a very similar situation. This was a sewer backup and flooding incident that resulted in some cost to the property owner. We did submit it to our insurance company. Their recommendation is to deny based on it being the contractor's responsibility.
Okay. Is there anyone from the public that would like to speak to this item on the agenda?
Jay Billings, Stevens Point, 1155 Ridge Road. We sought the same counsel as Mr. Glashinsky, and I'd just like to say carbon copy of everything that he spoke to. And that's pretty much all I have to say. Thank you.
Okay. Questions, comments from the committee?
I have one additional,
Oh,
if I may.
absolutely.
Thank you. One point, I think it's again, Jason Glashinsky, 2985 Maple Ridge Road. Again, it's important to understand, I believe, that having a contract does not free anyone from specific liabilities. So if the city fails to perform their due diligence, it doesn't matter what the contract says. You can have a contract with anybody that says anything that doesn't free the municipality from their legal responsibilities. And our contention is, and again, I don't want to speak for Mr. Billings, both Mr. Billings, but our contention again is that the city failed to perform their due diligence here. And so that's all I have. Thank you.
Thank you. Alder Keemer.
Thank you, Chair. I guess I have a question about the bidding process. I mean, typically when we bid out these projects, they go to the lowest bidder. Given these circumstances and what we've heard about this contractor, I mean, if this contractor comes out with a low bid again, is there leeway for, or discretion for us? Because often it's like the lowest qualified bidder.
Right. You're not obligated to take the lowest bid.
Okay.
That I know from my prior experience, so. Mayor?
If it's all right, Mr. Chairman,
Sure.
our rather than have Joel get up with an injury. If there's something I'm out of line on, you let me know. Just give me a head nod or something. But we are not obligated to take the lowest bidder. We are obligated to take the lowest qualified bid. Exactly. And there can be disqualifying features. You see the city attorney up here. He'll elaborate on that a little bit too.
Yeah, so qualified, that is a bit of phraseology you would hear is like qualified bidder. But you can also, there is a doctrine within public construction bidding law you can identify a bidder as being what's, quote, a irresponsible bidder. And, you do see some litigation about that type of stuff. Somebody puts in a low bid and you say, no, we're rejecting it. We're considering you to be an irresponsible bidder. You have to be able to provide a basis for that. You can't just do it arbitrarily. However, with regards to this particular contractor, knowing what we know from this project, were they to be the low bidder on a future project, I absolutely expect that conversation will occur. I wouldn't want to, stand here and commit one way or the other in terms of what we might determine with regards to that. We need to see the specifics and continue to see how this situation plays out. But that conversation will be had, guaranteed. But, the suggestion that the number of CCAP entries regarding a particular LLC is a barometer for whether or not a bidder is responsible. I'm certainly not aware of any case law to support that claim. My guess is if you take any of the larger contractors in the state of Wisconsin, type their name into CCAP, you're likely to find a lot of entries because doing a lot of work is going to lead to litigation sometimes. Sometimes that might just be a contract dispute, something about money, something about deliverables, and just, volume brings with it litigation inevitably. But our experience here with this is going to be informative if this bidder were to submit on any of our projects in the future. And if we end up in a dispute about them being identified as an irresponsible bidder, then I would invite their legal counsel to, clip and ship my words here at the mic. So,
thank you. Other comments?
I know in the past we have had some contractors bid on things and the city has said no throughout the year. So and when we do have a contract, my understanding is it's already vetted before it even comes to us, so that it is an actual valid bid, as opposed to someone who is someone who's not really qualified.
Any other comments, questions, or a motion would be in order?
Okay.
Alder Broderick, move to deny. Is there a second?
Second.
Second by Alder Morrow. Any other comments? Hearing none, all of those that are in favor of denying that claim.
I thought Alder Broderick was getting ready to say something.
Sorry.
I was sure thinking about it. I guess I'm curious, to the attorney's point, that the number of incidents is not necessarily representative to the failure rate if they are performing a high volume of work. But that being said, I'm wondering if the number of incidents as a proportion of the amount of work a contractor is performing is legally something that we can consider as a parameter when we're assessing bids, because it feels like it should be if it's not at this point.
Agreed. All right. All of those in favor of denying that claim would signify by saying aye.
Aye.
Aye. And all of those opposed to that denial would signify by saying no. So the denial stands. That'll bring us to item number 4, approval of funding for a contract with North Central Wisconsin Regional Planning Commission for assistance with a comprehensive plan rewrite. Director Kivala.
Thank you very much. So there's a memo in front of you. I am filling in for Chris here, gave him the night off. But Chris and I were talking about the comp plan when I came on board. Previously, Director Karnofsky had started a new approach with this comprehensive plan to take more of a neighborhood look at things. Through exercising that approach, staff did discover it was taking a long time, pretty inefficient, although innovative, and a noble effort. It was inefficient taking a lot of time, and as we've heard at many meetings, people are consistently pointing out the age of our comp plan, which is not a problem other than it has not been looked at for a while. Upon exploring other options, we decided to go back to the standard format of a top-down approach for a comp plan. We also began talking with different individuals that have gone through the comp plans, past directors at the county, et cetera, and they had really recommended working with North Central Wisconsin Regional Planning Commission, as they have been the kind of leader in our area for assisting in these. So to stick to a tighter timeline, with the understanding that, we do need to update this product, and try to get the best product, something that's accurate, concise, usable. We are looking to partner with North Central Wisconsin Regional Planning Commission. Although we are a member up to that organization, there is still a fee for doing this work. They did quote approximately $32,500 to assist in this 12-month process. So staff is looking to request up to $35,000 to assist with this contract and with this work. I will note we've already talked with the comptroller about a funding source for that, and we do believe that there is ample amount of funding for this.
Okay. Comments, questions by the committee? I guess I would just say there's been a lot of discussion on the comprehensive plan, and I think we all acknowledge the need for it to be updated, and so I think it makes sense. A motion would be in order. Is there a motion?
I'll move approval of the contract.
Alder Keemer moves approval. Is there a second?
I'll second.
Second by Alder Broderick. All in favor of approving the funding for the contract with North Central Wisconsin Regional Planning Commission for the assistance with the comprehensive plan rewrite would signify by saying aye.
Aye.
Aye. And opposed to be no. And that passes as well. That then brings us down to item number 5, approval of the lease of city-owned land for farming purposes with Bernard Mocadlo.
I should try to do this at every meeting. I'll ask and then I'll give. And not me giving, but Mr. Mocadlo. So Bernard Mocadlo had reached out to staff and inquired about leasing the farmland that the city has purchased out on Old Highway 18 for the purpose of farming. His first question is, were you going to develop it this year? Our answer was, we do not have a developer at this time. And with the understanding that it would take at least 6 months for any developer to truly get up and running, staff felt as though it was a pretty safe option to lease out this land to Bernard Mocadlo. So it'd be approximately 100 acres at $125 an acre, which through staff's research is a very fair price, and also the same price that he paid last year. So that would total $12,472.50 coming in for this farming lease for this year. I will note there's also another portion of land that the city purchased in the industrial park area on that side of town. And that farmer also would like to enter into an agreement. So that will be coming forward in the future. But this request is just for leasing land to Bernard Mocadlo up by Old 18.
Okay, thank you. Any questions from the committee? The director? Any comments, thoughts? Committee? Public? Hearing none, a motion would be in order.
So moved.
Moved by Alder Morrow to approve that lease. Is there a second?
I'll second.
Second by Alder Keemer. All in favor of that, approving that lease would signify by saying aye.
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 Aye, and opposed would be no. That is approved as well. Our final item on the agenda is approval of claims paid. Comptroller, anything that you want to point out specifically?
Sure. So you'll notice we've got some large payments to the school district, county, and tech college, and that's the result of our tax settlement process where we collect the taxes on their behalf and then forward those payments on to them. And then you also have the McDill Lake District dues that we collected on behalf of the Lake District and then paid over to them. And then you also have the room tax payment to the Convention and Visitors Bureau. So basically, we collect room taxes quarterly, and then we forward 46.86% of those collections to the Convention and Visitors Bureau.
Okay. Any questions from the committee? Hearing none, is there a motion?
Move to approve claims paid?
Motion to approve by Alder Broderick. Is there a second?
Second.
Second by Alder Morrow. All in favor of approving claims paid as presented signify by saying aye.
Aye.
Aye, and opposed would be no. And that passes. We are adjourned at 6:33.
A video of this meeting is available for viewing on the city's website, stevenspoint.com/videos.